Hi, everyone. I'm Duncan Hollis. I'm a non-resident scholar at the Carnegie Endowment for International Peace and a law professor at Temple University's School of Law. And I'm here to talk to you today about all the threats we're seeing in cyberspace and one particular tool, international law, we might use to help reduce such threats. Over the last few years, I think, as many of you know, cyber threats have become an increasingly visible and dangerous occurrence. We've seen ransomware against the largest US oil pipeline. We've seen cyber attacks on national healthcare systems and hospitals, notwithstanding a global pandemic. And we've seen this past summer destructive cyber operations aimed at entire countries, the likes of Montenegro and Albania. All these cyber operations are causing tremendous economic losses. They threaten national security and even human lives. And at least some of these attacks appear to be coming from states themselves. According to the Council on Foreign Relations, 34 countries have been identified as conducting so-called cyber operations against foreign targets, including countries, firms, and individuals like you and me. Just in 2019 alone, there were 76 of these state-affiliated cyber operations, and they obviously cry out for solutions. And some of these solutions are technical, improving how technology is used to provide cybersecurity. And indeed, in the first DPN University video, Herb Lin explains some of these technical tools. We might also use national laws to try and identify and hold hackers accountable. And so a number of countries like the United States have begun to indict hackers, even those who work for foreign governments. But I'm here to talk about another ready-made tool for dealing with these cyber threats, and that's international law. International law is a set of rules and standards that direct what states can and can't do, not just offline, but online. I want you to know that cyberspace is not some wild west where anything goes. Everyone agrees that international law applies in cyberspace. And yet, for all that agreement, countries have yet to actually agree on how it applies. Today, governments and their international lawyers who advise them appear bogged down by a diverse set of disagreements and divisions. So in this video, and one more to follow, I want to try and explain these problems to you. After all, to fix any problem, you have to first understand it. At the same time, I don't expect you all to be experts on international law and all its terms of art. And in fact, I think I can teach you all that you need to know about applying international law in cyberspace today if you remember just 4 things: Jean-Paul Sartre, Carriages, horses, and Simon and Garfunkel. I know, it's a strange list, but the idea is that it's so strange that it'll be easy to remember. A mind map, if you will, to understanding what's causing the current obstacles to move from existing lip service to applying international law to actually doing it, right? Holding those who violate its rules and standards accountable. So in this first video, I'll talk about the first 2 things of our mind map: Jean-Paul Sartre and baby carriages. If you watch my next video, I'll talk to you about what horses and Simon and Garfunkel have to say about international law in cyberspace. Ready? Okay. First up, Jean-Paul Sartre. Sure, you may know him as one of the leading thinkers in the philosophy of existentialism, but for me, he symbolizes the idea that there are existential challenges to international law in cyberspace. In essence, we face the question of whether and which international laws apply in cyberspace. Now, for a time, some states had a real existential debate about whether international law applies in cyberspace at all. That debate largely receded as the UN General Assembly, and with it almost every country in the world, has agreed that international law does indeed apply in the cyber context. Other international organizations like the European Union, the ASEAN, the Organization of American States, they've all reached the same conclusion. Nonetheless, existential debates over international law remain. It's just they're no longer about whether international law as a whole exists in cyberspace, but which particular regimes of international law do so. So we've seen some states question if the right of self-defense or international humanitarian law, that is, the laws of war, apply in cyberspace. Others question whether this idea of sovereignty actually exists as a rule in cyberspace, as it were. In 2018, and again this past summer, for example, the UK Attorney General made clear that although the principle of sovereignty is fundamental to the international rules-based system, the United Kingdom is not persuaded that it constitutes a standalone rule prohibiting certain cyber activity. The way, for example, sovereignty operates to preclude one state's aircraft from crossing into another state's airspace. Other states, though, like France, the Netherlands, and Finland, disagree. And they insist that cyber operations that have any impact on another state's territory, whether or not they're trying to coerce the victim state or use force against it, these will violate this idea of a rule of sovereignty. So I think resolving existential debates can be challenging because they triggered conversations where the sides disagree entirely, right? Either the laws of war apply online or they don't. Yet figuring out which existing rules of international law are relevant online is critical, right? States have to know, for example, what are the existing rules and standards of international law, like human rights, like due diligence, like the laws of war, to be able to know whether or not state behavior can be regulated online. So that's Sartre and the existential challenges to international law applying in cyberspace. Now let's shift to baby carriages. Even where states agree on the relevant international law rule, we're seeing a second challenge, and an interpretive one, if you will. A challenge about what the rule means in the often novel contexts that information and communication technologies create. So for me, the baby carriage symbolizes the challenges of interpreting those rules that we do agree apply in the cyber context. It's an example I draw from a famous debate between two of the 20th century's most prominent legal philosophers, H.L.A. Hart and Lon Fuller. In their debate, H.L.A. Hart described a public park, and he said, imagine it has a sign at the entrance that says, quote, "No vehicles allowed in the park." Hart asked, well, what does that rule mean? He assumed that the rule kept out things like cars, right? Things with four wheels and a driver. But he asked, well, does that rule apply to toy cars? What about bicycles? After all, what makes a vehicle a vehicle? Is it something with wheels? Must it carry a person? Lon Fuller went even further and said, what about baby carriages? A four-wheeled vehicle used to transport a human. Are baby carriages prohibited by a rule that says no vehicles in the park? The baby carriage debate demonstrates how, even when there's agreement that a legal rule applies, challenges remain in determining what such rules mean in practice. It's hard to know, for example, what about public parks and vehicles we should, decide where the lines will be drawn. Just as it's hard to say, what does international law mean when it prohibits states from intervening in another state's internal or external affairs through what is known as the duty of non-intervention? And as you might imagine, there are many unsettled interpretive questions about how particular rules of international law apply in cyberspace. For example, Article 2, Paragraph 4 of the UN Charter prohibits states from using force unless done in self-defense or with the Security Council of the United Nations authorization. What does that prohibition mean for cyber operations? Whatever the colloquial usage of the term cyber attacks, there's a long-standing question surrounding the threshold that must be crossed for a cyber operation to constitute a prohibited use of force under the UN Charter. Similar interpretive questions surround the idea that the duty of non-intervention requires coercion. But what does coercion mean online? Does it include or exclude, say, information operations targeting our electoral processes? In many cases, interpretive disputes end up as debates over default rules. In other words, when we have novel behavior, something we haven't seen before, where do we fit that behavior along the spectrum of existing permissions and prohibitions? Do we assume that anything that's new must fit within a prohibition, or does it fall outside of that prohibition and is permissible? What's the default condition for cyberspace? So, Jean-Paul Sartre, baby carriages. Two things I admit at first appear pretty unrelated and completely irrelevant to international law and cyberspace. But looking at them from a different way, they highlight both the existential and interpretive issues that currently cloud international law's application to state behavior online. In the next DPN episode, I'll dive further into two other challenges for international law and cyberspace: horses and Simon and Garfunkel. Hope you'll join me.